Welcome to Moonstone Update. I'm Mark Bechard, the Managing Editor of Moonstone Publications. Here's a look at some of the stories we've covered over the past week, but first please hit the subscribe button. Share this video with your friends and colleagues. The FSCA has released a draft notice that aims to sort out the confusion over when intermediaries can be remunerated after a pension interest has been transferred between retirement annuity funds. Section 14 of the Pension Funds Act and the Long-Term Insurance Act's regulations do not address this issue consistently. The guidance note sets out the conditions that must be met for intermediaries to receive fees that exceed the maximums in the regulations once RA assets have been transferred. Moonstone Compliance has launched an employment law service, providing comprehensive advice on managing all aspects of labour relations for businesses, no matter how big or small. Our employment law service will ensure that your workplace procedures comply with legislation, from recruitment and selection to dismissal for misconduct, incapacity, or operational requirements. Follow the link below to see our full service offering. The FSCA is proposing to increase the FAIS Ombud's compensation limit from R800,000 to R3.5 million. A study by the World Bank said the current compensation limit, which was set in 2004, should be reviewed. The limit has not kept up with inflation and was out of kilter compared to other ombuds in the financial sector. Pending regulations flowing from the Retail Distribution Review will not be processed in their current form, but will be incorporated into new regulations that will be developed under the Conduct of Financial Institutions Bill. This has emerged from the FSCA's regulation plan for the next 3 years. The plan outlines the FSCA's high-priority, conduct-focused regulatory changes for advisors and intermediaries. A financial services tribunal decision should clear up any potential confusion over whether a reconsideration application can be brought by a representative who was still embroiled in litigation with the FSP who debarred them. The representative was dismissed for misconduct and then debarred. The CCMA overturned the dismissal, but his employer took the matter to the Labour Court. The representative was under the impression that Board Notice 82 of 2003 prohibited him from bringing a reconsideration application while the Labour Court proceedings were pending. The High Court has ordered Sasria to settle a claim by a company that lost its equipment when a colliery was flooded during labour unrest. Blackspear took Bright and Sasria to court, contending that either insurer, or both, were liable to pay compensation for its loss. The mine was flooded during an underground sit-in by mine workers. Sasria disputed that the labour unrest was the proximate cause of the damage. A sign advertising instant loans and employees' verbal information that interest of 30% a month was charged on short-term loans were a reasonable suspicion for the National Credit Regulator to initiate an investigation into contraventions of the National Credit Act. The Supreme Court of Appeal said although instant loans may merely mean swiftly, it could reasonably suggest a less onerous loan application process. That's all we have for this week. You can read these stories and many more on our website moonstone.co.za. Until next time, here's wishing you all the best from the team at Moonstone Information Refinery.